Any mention?
May it please, Your Lordship.
Yes.
I beg to mention item number 3 and number 4 of the daily list, Your Lordship.
Item number 2 and 3.
3 and number 4.
3 and
Lordship,
all cantonment matters. Nothing has come till now. Nothing.
No, similar matter has been heard by Honorable Justice. Thank you. It is fixed on 21st again.
It is
If that
pending
is
for
decided,
judgment.
then this will be covered.
It's pending for judgment there or hearing concluded. What's going on?
Hearing part of that matter.
Your Lordship, I humbly pray for 4 weeks' time, Your Lordship.
4 weeks will be too long. We'll give you 3 weeks.
3 weeks, Your Lordship.
3 and 4.
Yes, Your Lordship.
Just on the joint request of the parties, this is matter after 3 weeks.
Highly obliged, Your Lordship.
Your Lordship, I beg to mention item number 9 of the hearing list. So this is an application under section 482, which is filed on behalf of Mr. Upadhyay's legal aid, challenging proceedings under the POCSO Act. Lordships will recall this issue is pending before the Honorable Supreme Court. That judgment is still not out.
That is married. The ground is that,
Lordship.
that parties got married.
There was a settlement between the parties.
Yes, sir. Okay. So we'll have it after 2 weeks.
Lordship,
This
2 weeks.
okay? This on the joint request after 2 weeks.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 8.
Yes. You are for petitioner.
Yes, Your Lordship.
Mr. Sangresho is there in this matter. Item number 8.
Yes, Your Honor.
Mr. Sangresho is there.
Yes.
I'm also
Yes,
unable
yes.
to prepare today.
It's all right. There is no.
Just only
Your
a
name
week time.
appears, so that is why the question is.
Only a week time.
When do you want it?
After 2 weeks' time, Your Honor.
Yes, on the request meet.
Please, Lordship. Lordship, I beg to mention item number 2, Lordship.
Item number 2.
Lordship.
Why? You are
Lordship, we were supposed to file an affidavit in reply to the affidavit filed by the petitioner, Lordship, with regards to bringing on record the tripartite agreement. Lordship, I've just received the instructions on Sunday, Lordship. I just need a few days time, Lordship, to.
Who is the other side?
Lordship, she's.
Lordship, I am appearing for the petitioner.
Why
Lordship.
this monitor is not working? Have you informed the other side?
Lordship, I have.
Lordship, yes, day before last.
Yes. Okay. So
Lordship, yes.
Lordship, 1 week's time, I'll prepare the affidavit.
just see. This is matter after a week on the request of Mr. Learned Counsel looking for the state.
Highly obliged.
Will come after.
Obliged, Lordship.
May I please, Lordship, I beg to mention item number 5 and 6, Your Lordship. I am prepared this matter be taken up for 2
5 and
weeks.
6. Nothing would remain in the list, I think. Probably. Yeah.
5 and 6, Your Lordship.
Yes.
And for 5, Lordship. And for item number 5.
Yes. And then
We have no objection, Lordship.
both are same matter.
Yes, Your
These are
Lordship.
related matters. These are
Yes, Your
connected
Lordship.
matters.
Yes, Your Lordship.
Quashing.
This is a juvenile matters, Your Lordship.
The entire list will be exhausted. Okay, 5, 6. When do you want?
After 2 weeks, Your Lordship.
After 2 weeks, the request made on behalf of the petitioner. Yes.
Multiply, Your Lordship.
Lord, I beg to mention item number 7, my lord.
You will take up. Why?
Tomorrow, my lord.
Why tomorrow? Today? What is auspicious about tomorrow?
No, my lord. Today
We'll
I
have
will
it
not.
today. Let us see. Let us see
My
what
lord,
happens. Just we'll start. If there is any difficulty, we'll let you.
Daily list, item number 1.
Yes.
Now, this matter also relates to 482,
Yes.
quashing of the trial. But what happened is this is a POXO. The accused person was slapped with the section 9K of the POXO Act. Now, trial is going on in Northern Court. Now, after
Yes.
My lord, this is a
If there
revision.
is any real difficulty, then we will adjourn.
My lord.
Just please give us the story.
My lord, this is a revision application, my lord, against the order dated 23/5/2023, my lord, by which the Linear Trial Court has allowed the application under 311, my lord, thereby recalling the for examination of the PW1, my lord. The PW1 is the complainant in this case, my lord. My lord, the impugn order is at page 44, my lord.
Page 44, yes.
My lord. My lord will see, my lord, there's no ground assigned, my lord, on the basis of which, my lord, this PW1 is recalled, my lord, for examination.
Let us read the order.
My
Just
lord.
see.
My lord, the operative portion is the last paragraph, my lord. May I read the entire order, my
Yes,
lord?
it's a small order. Read the
My
entire
lord,
order.
CR put up accused Sri Nisal Ramurang is present with his defense counsel Srimati Soenso. Learned PP Soenso is present and submitted that the petition under section 311 CRPC white petition number Soenso for recalling of PW1 complainant filed by him on the last date as because some development has come to light from the evidence of other witnesses which requires to be tested from the complainant and that he has omitted to us some facts from her as per her statement in CD. The learned defense objected the recalling of the complainant as she has already been examined both in chief and in cross. She further objected on ground that no development of any fact from the other witnesses. Defense objected recalling of the complainant at it will amount to harassment to the accused, and she submitted that the learned PP should have invoked 154 Indian Evidence Act at that relevant time. As per provisions under section 311 CRPC it is provided also for recalling and re-examining of any person already examined if his evidence appears to it to be essential to the just decision of the case. It is settled law that the discretion is vested in the court under this provision where is to be exercised judicially and not arbitrary, and that the witness may be recalled or re-examined at any stage or proceeding where is essential. On going through the recorded evidence and statement of the complainant under section 161 CRPC and also confessional statement of the accused, which learned PP submitted, will also be filing application for recalling of the for calling the recorded magistrate is seen some essential facts requiring to be extracted from the complainant in order to enable the court to reach at a just decision of this case in respect of the cause of death of the baby child. Hence, the prayer the prosecution is allowed prosecution to take steps to PW1 accordingly fix so and so.
What is the wrong?
My lord may kindly see the application filed by the prosecution. That is at page 42, my lord.
Page 42.
My lord. The application is totally vague, my lord. There is no reason assigned, my lord.
See, unlike a civil case,
My lord.
in a criminal matter, you cannot say that nobody can plead beyond.
My lord,
Nobody can raise ground beyond pleadings.
my lord, on the ground on which, my lord, the PW1 has been recalled for examination, my lord, those are already on record, my lord. The statement of the complaint under 161 and the confessional statement, they were already on record prior to taking evidence, my lord. My lord, section 311 may not be
Can I
allowed
quote-
for the
can I-
filling up of the lacuna of the prosecution, my lord. This is. But
There is nothing apparently wrong. This trial court has a discretion to do that.
my lord, that is settled, my lord. That is settled. I have checked the judgments, my lord. But my lord, it may not be allowed, my lord, for filling up of the lacuna of the prosecution evidence, my lord. This is only for the filling up of the lacuna because they could have whatever is required, my lord, to be examined, my lord. They could have done well. She was examined under 164, my lord.
No, what required is that, you see, like here, the recording of further evidence.
My lord.
Apex court in the in terms of the various judgment rendered by the apex court is that. Say supposing any examination which is necessary for disclosure of truth before a criminal court, that should be done. And it is a trial court to judge. They are the best judge to see what is essential and what is not essential, to unfold the truth in a criminal matter.
My lord, but there, my lord, on the application, my lord, can you see the application? There should be some specific reasons, my lord. The purpose of summoning the witness, my lord, that is also not mentioned, my lord. What is the purpose of summoning the witness, my lord?
But then the impugn order has some reason in it.
My lord?
The impugn order contains some reason.
My lord, that it is...
We'll give priority to it. Forget about what a written petition criminal proceeding mean. What relevancy it would have. Say supposing if they fail to omit something, then also what happens? What is the consequence? You cannot say, unlike the civil case where the party is not allowed to make contention beyond the pleading. Cannot. So that is. Can we apply the same proposition of law in a criminal case?
That is cannot be, but no, there has to be some reasons, my lord. That is also, and my lord, the impugn order also does not say exactly on what, my lord, the impugn order also doesn't say, my lord, on what ground she has been recalled, my lord. Only the confessional statement and...
See the last paragraph of the order. On going through the recorded evidence and so on. See that they are the ground. It says it is seen some essential facts requiring to be extracted from the complainant in order to enable the court to reach at a just decision of this case in respect to the cause of death of the baby child. Hence, the prayer of the prosecution is allowed.
But all the witnesses has already been examined, my lord, in this case. Total 6 witnesses, they are already been examined, my lord. After 1.5 years, this application has been filed, my lord. And she was examined, my lord, in the year 2022, my lord.
It's 482, isn't it?
397 read with 482.
Revision. Now you have to say some sort of, jurisdictional error by the court. In the sense, the revision, unlike appeal, until and unless you point out that trial court has basically travelled beyond some limitation, or the order could not have been passed in the manner which has been passed, then there may be a chance. Otherwise, this court finds that yes, court has recorded reason. It is not that that court has passed the order without recording any reason. Now, the sufficiency and insufficiency of the reason not required to be examined in every case.
My lord.
It is not that there's something the court was not empowered. You are not challenging that part.
No, has the power. That is, court has the power.
Your argument is confined to the reason which has been reflected.
What is the purpose of summoning the witness, my lord? That has not been mentioned, my lord.
Essential facts. The court cannot say what are the facts. Because if you say that, then you will say court has already taken note of that. So, court said some essential facts has to be extracted from the complainant. That is what. If you have something to show that this kind of order cannot be passed, then definitely.
My lord, give me some time, my lord, if I can go through some judgments.
That you will get right from the beginning, court said. Court said that you will have if there is any difficulty. But then, see, madam, there I think this arena is one arena. You will not find a, there are decisions this way, that way.
My lord, I have seen
many decisions, especially in recent years. So that is where you have to see.
My lord, may fix it day after tomorrow, my lord. I don't.
You go to next week. You will not fix it day after tomorrow. Just how many times you can call to witness? Once a witness is examined, cross-examined, then how and when you can call him again? It is not that person who has not been called, you are calling him under.
My lord, my verbal instruction is that, my lord, what had happened, the complainant, PW1 complainant, throughout 161, 164, statement before the doctor, she was consistent. Suddenly, during the examination chief, she almost turned hostile. So, my lord, the prosecution had no other thing. So,
So
therefore,
you have not declared a person hostile.
no,
so
no,
you
no,
just to
no, 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 no.
No, my
She answered certain questions, but very vital questions were not
not been
answered.
put, my lord. That is the
Not put,
now,
or she
my
did
lord.
not
They
answer.
are
If I may, or you want to
no,
continue?
my lord.
Please?
sit down, sit down.
So, my lord, what had happened later on, after she was let go by the court, honorable court, my lord, later on it was found out, my lord, that during the entire episode, during the investigation, and because of this unfortunate incident of the death of the child, my lord, they were living separately, the accused as well as the victim, my lord. That was the impression in the court, my lord. Initially, they were staying separately, which is why her statement under 164, 161, and before the medical doctor was very consistent and to pinpoint it, my lord, putting the allegation on the accused person. Later on, during the trial, my lord, even before the examination PW1, my lord, it so happened they had already started staying together, and they were internally they had compromised the matter within themselves. That was the reason the court noticed as well as the prosecution that, oh, this was the reason she did not, my lord, explain, and she completely took a U-turn from the statement she had given under 164, 161. So for this
You
purpose,
should
my
have
lord,
declared her hostile at that point of time.
that was not
Examined.
that was not done, my lord. However, my lord,
So if it is not done, to correct that lacuna, can that person be called again just for the purpose of declaring her hostile?
my lord, this impute order challenge before your lordship, my lord. Kindly, my lord, both the parties were heard at length, my lord.
You can understand that.
And my lord, the law is that, my lord, the trial judge need not pass elaborate order on that, my lord, to exercise power under 311, my lord. The trial court is.
Can that power be resorted to correct the lacuna?
This is not a case of, my lord, purely lacuna, my lord. Here it is a case where a.
No, but then the background, which whatever you have given, that there is a change of attitude of the.
That is off the record, my lord. What my learned
But then
friend.
you have narrated before.
Yes,
before
my
report. That has come during the course of hearing. Now, just to cover up that, that seems.
Whether, my lord, that will come. Sorry, my lord.
It seems now from your submission makes it clear that you did not get that your expected thing there, so you want to correct it.
My lord,
it is not that some facts are left out.
My lord.
You see, maybe 311, even the person who has already been examined, can be recalled again if certain vital facts are missing. But then if it is for the purpose of, bringing the witness with an aim to correct that earlier deposition,
my lord,
then it may not be allowed.
My lord, in that case, my lord, the term lacuna, filling of the lacuna itself, my lord, whether withholding of the information by the witnesses, that comes within the, my lord, definition of covering of the lacuna, my lord, filling of the loopholes, my lord.
No, but then
I think, my
it
lord,
is your witness. If witness doesn't
exactly,
depose,
my lord.
that is
Let my
is
friend
for
come, and the next week, my lord, I'll satisfy her also. In fact, I have got the judgments now, my lord.
No, there will be judgments. There will be definitely judgments. This way, that.
My lord.
One thing is here that until and unless you can show
I
that
think
there
my
is
lord
some
will-
glaring illegality.
My lord will remember, my lord, there was a case recently from Nangpo where in a POCSO matter, the doctor was summoned again for a few questions that were omitted during the, my lord, examination chief. And the prosecution filed a application with 311 that was rejected. And my lord, I was standing from the government side. Lordship had, my lord, passed that order, my lord, allowing the recall, my lord, on the same footing, my lord. Yes, my lord. So let my friend come, my lord, next week. Of course, it's a food for thought, my lord has given enough to both of us.
No, it's a learning for the court.
My lord,
You see,
my
like
lord,
from
my
where.
lord. I'm honored, my lord.
You see. Anyway, we'll just say on the request, on the joint request list after a week.
Deeply obliged.
Item number 10.
My lord, in this matter, my lord, the state was, as per the last order, the state was directed to produce the case diary, my lord. The charge sheet, my lord.
Yes. Yes, Mr. Even, what is the matter about?
Yes, my lord. Before my lord goes into the charge sheet, my lord, this is an application under section 480.
Mr. Gurung, you have given the original, or this is a copy?
My lord.
It's a copy or?
It's a copy, my lord.
Yes, we can retain it.
Yes, my lord.
Yes. So, my lord, this is an application under section 482, my lord.
Yes.
The prayer in this petition is for quashing of the FIR, my lord, on the basis of, number one, the first ground is that this is an absolutely an abuse of the process of law. And why do I say so is, this FIR, my lord, has been derived with malified intention or with disgruntled to make a score against me, my lord. And I can, by merely going through, before reading the FIR, my lord, I can substantiate that. And also, my lord, when we read the contents of the FIR, my lord, nowhere, no ingredients, my lord, would find that any attracting any offenses, my lord. Yet, my lord, now what they have said that police has registered the case, investigation has completed, and the charge sheet is submitted before my lord. I don't know what is the incriminating circumstance or documents.
You have received a copy of charge sheet,
We have not, my lord. We have not even received a notice of someone from the court, my lord.
Yes.
But be as may be, my lord, this charge sheet was filed subsequently after registering of my FIR or of the FIR, my lord. Before, my lord, I will take to the FIR, my lord. I will like to show few of the pages, my lord, which I have annexed with my petitions, my lord. And first of all, I would like to start with Annexure 1, page 14, my lord. Annexure 1, page 14. And then I will read the FIR, my lord. Annexure 1, page 14. This is the certificate, my lord, which I have issued to the complainant here, the private respondent here. And if my lord sees... Private respondent, my lord.
Oh, you are...
Yes. So, my lord, if my lord sees the last...
You are the complainant.
I am the complainant. I have signed the FIR.
Yes. If my lord sees the last line, my lord.
Yes.
And it's stated 2018. 2018, that the one word. This figure is very important here, my lord.
Which part you are...
My lord, may I just read the entire thing then? It's a
No, just read.
certificate and authentication certificate, my lord. This is to authenticate that the two following works of Mrs. So-and-so, that she has conducted and led leadership camps in Meghalaya and notably led a contingent of guides to Philippines in the Asia Pacific Scout Jamboree in the year 2009, as well as serve as international service team in any area of activities with huge exposure to international and national communities as required in our organization, the Bharat Scouts and Guides. Although not fully employed, Mrs. So-and-so has been serving as honorary non-salaried assistant state organizer and a member of the state executive and state executive of the Meghalaya Bharat Scouts and Guides since 2018. And this is under my signature. My lord will see the contents of the certificate, my lord.
This certificate is issued by you?
It is issued by me. It isn't admitted.
You admit?
Yes, this I admit.
Then what is the problem then?
Now, my lord, it will come little later, my lord. I will explain. Now, my lord, kindly look at the contents of this certificate, my lord. These contents of the certificate talk so kindly about the complainant. So kindly about the complainant. No remorse, nothing, no black remarks against it. Rather, I am promoting her career. This is stance. Now, my lord, thereafter, at the following page, my lord, page Annexure 2, page 15, my lord.
Yes.
My lord, this is an advertisement for filling up of various posts issued by Meghalaya Public Service Commission. And my lord, the relevant for us would be page 18, serial number 13, my lord. I'm just trying to build up the circumstances that led to filing of FIRs, my lord. So, page 18, serial number 13, it talks about state organizer, scouts and guides. This is a post that has to be filled up, the two posts. My lord, I'll just read, this is important. So, experience, my lord. From the experience, it says, serve as an assistant organizer for more than 3 years in the state or in other Bharat Scouts and Guides, must have completed so and so, so and so, so and so, so all things. Now, my lord, it says 3 years of experience as on the date when the advertisement has been issued. So, this particular complainant.
This advertisement was issued on 14th November 2000.
Yes, my lord. So, as on that day.
Just a minute. Just clarify. Just confusion.
Yes.
Sorry to interrupt.
Yes, my lord.
Your certificate is dated 2021.
2021.
So it was issued much after the advertisement.
No, this advertisement is of 2019, my lord.
Yes.
2019.
And the certificate is of 2021.
Yes, my lord. Because then, due to some, I think in that period of time, this was not filled up, and subsequently applications were called for. So maybe there was some delay in this. Therefore, then she come to ask for the certificate, most probably because she wanted to apply for this post. Because of COVID and all this,
The fact remains this certificate was obtained much after the advertisement.
Yes, much after the advertisement, my lord. Now, my lord.
What is the last date for this thing? Applying here.
My lord, this was because this 2019 was applied, of course, but the thing is that
was there, but then when was the last date for making application?
Last date for making an application is up to 1700 hours of 23rd December 2019.
So
2019.
So what the certificate has to do with this?
But my lord, initially she must have submitted, and then she wanted a certificate. Therefore, we have given the certificate, my lord. But be as may be, my lord, let me just build up my case first. My lord will see this one. So
you build up your case, but then the court should understand. That is what.
Yes, my lord. Absolutely. So, my lord, now this experience says that serve as an assistant organizer for more than 3 years in the state or in another Bharat Scouts. So, as on the advertisement date, somebody should have served for at least 3 years. That is what the requirement, minimum requirement, as far as the experiment is concerned. So, she has also applied. The complainant has also applied, and she was qualified. She was qualified to appear for the interview. Now, my lord, page annexure number 3, my lord. Now we will come to annexure number 3. There was another candidate, my lord.
Yes.
There was another candidate by the name of Srimati Dashimti Kharkungor. Now, this candidate was appointed as an assistant state organizer. She applied for the post. And now in the SAREC list, when she came to know that the private respondent also got qualified, and now she is this lady was very much aware that there was just 3 years of experience required. So that is the reason why she filed an application, saying that wanted to find out.
This is an application under RTI.
RTI, yes. RTI by another candidate.
Yes.
So
this is Dashimti Kharkungor.
Yes. So she on 14/11/2021, she has filed an application and wanted to examine the documents. What are the documents that the private respondent have annexed, which has entitled to enable her to be qualified, to select, to be eligible.
This lady was also a candidate.
Yes, she was a candidate.
And she did not become successful.
She did not come successful, but before that, she has already filed this RTI. Before that. Now, my lord.
Before that means before the results were?
Before the results, yes, ma'am. Now, my lord, she was allowed to go through the documents in the MPSC itself. So by this annexure 4, she was allowed to go through, and in this annexure 4, my lord,
So you can inspect in person.
yes. So when she inspected in person, she found one certificate, experience certificate submitted by the private respondent, and that certificate, my lord, is at page 29, my lord. Page 29.
Yes.
And page 29, my lord, everything, the contents is same, except for the year. Now here is 2016.
Okay.
My lord, got it? 2016.
Now date of issue also is same.
It is same. Everything is same. The year has changed here, 2016. Now, my lord, if the original certificate which was issued by me is 2018, that certificate does not entitle her to apply for the post of state organizer as per the advertisement, as per the requirement of the advertisement. Now, if this 2016 application is shown, then this makes her eligible to apply for the post, because then she fulfills the criteria of 3 years of experience.
Now both these certificates,
yes,
are issued by you,
my lord.
Isn't it? As it
2000,
as it appears.
my lord. Yes, my signature is there, but 2016, this one.
No. See, there are two certificates.
Yes,
Now,
two
according to
certificates are
you,
there. Yes.
Which one you have issued?
I have issued a 2018.
The first one.
The first one.
The second one is.
The second
not
one is.
issued by you.
It is not issued by me. This is what I clarify to the MPSC.
Forged by the private.
Forged by the private respondent. Yes. So now, after this, what happened is that this was brought to the notice because Dashimti Kharkongor is the one who questioned to me. He said that, Madam, you know very well this lady has never joined 2016. How did you issue a certificate saying that she was working from 2016? Because in the organization we all know. Then this lady, then she said that no, I am not I have issued her a certificate, but it's not 2000. I have issued her a very genuine certificate. 2018 she joined. I've given her 2018. Since 2018 she has been working good. But 2016, when she is not there, why should I issue her? So what happened now? This was brought to the knowledge of the MPSC. MPSC seems to have issued a show cause notice to the private respondent. Now, when the issue was, when the MPSC has issued a show cause notice to the private respondent, taking that we will take an action against you, what did she do? She went and filed an FIR against me. That is Annexure 8, my lord. Annexure 8.
She filed FIR against
She filed an FIR against me, whereas
After issuance of the first certificate, you were nowhere in the picture.
No, I am not aware in the picture. Yes.
Now this initiation of the recruitment process,
RTI,
participation, RTI, you were
yes,
nowhere.
yes, nowhere.
Now whatever thing, another certificate
Yes,
came into existence.
yes.
After this RTI
RTI, yes, yes.
was responded by the
Yes, yes. And I was also asked by the
But
MPS.
this certificate,
Yes,
apparently it was submitted by the private respondent.
private respondent.
So the onus is on her to
Exactly.
clarify how it came into.
Exactly. Now, in order to wash off her,
She filed an FIR against you.
against
Saying
me.
what? Saying what?
What she is saying that, my lord, the FIR is at page 30, Annexure 8.
Very interesting.
We'll answer.
Definitely there will be answer.
First information report, my lord. May I read the entire thing, my lord? In drawing your attention to the subject cited above, I so-and-so would like to bring to your notice that I have applied for the post of state organizer, Baraskov, White so-and-so, and I have been declared as eligible candidate for the post vice so and so issued by the MPSC. To my utter shock and surprise, I received a letter dated 2nd February 2022 from the Public Information Officer MPSC informing me that the certificates produced by me before the MPSC suffered from discrepancies and directed me to show cause as to why action would not be taken against me as per rule. I appeared before the Commission on 04/02/2022 and produced the documents. I had also filed my show cause on 07/02/2022. In my show cause, I have made a request to inquire and call for expert opinion to verify the genuineness of the certificate produced by me. The then State Secretary Meghalaya Bharat Scouts and Guides, Srimati S. Weir, had issued me a certificate bearing number 090/2022, wherein it was stated that I was holding the post of the state organizer since the year 2016. However, it came to my knowledge that Srimati S. Weir had approached the PIO of the MPSC by way of RTI petition and submitted a certificate bearing so and so, whereby the year of the service as assistant state organizer was recorded since 2018.
That means, just a minute, can you just pause?
Yes.
What is the meaning of this paragraph? It means that you have approved.
Yes.
MPSC.
Yes. I have approached.
Okay.
Yes.
Now, her case is that this 2016 was 2016 certificate.
Yes. No.
I mean, like
yes.
the
Yes.
certificate
Yes.
showing that she was in the job from 2016
Yes.
was issued prior to that 2018.
Yes.
Which you submitted later to MPSC.
Yes. Yes. Now, what happened was, my lord, when this part I need to explain, my lord. This part, what happened was.
Let us just go.
Yes.
See, give
Yes.
your explanation later.
Yes.
Just. This code is just trying to get the meaning, nothing else.
Yes.
Whatever the literal meaning is
Yes.
derivable from the.
Yes. So, my lord, the next last paragraph. From what it appears, the then State Secretary of Meghalaya Bharat Scouts and Guides, Srimati, is trying to blame and accuse me of submitting fake documents before the Commission so that I will be declared as ineligible candidate for the Commission for the reason best known to her. The fact is that I have been working as Assistant Scout Organizer, non-salary, since the year 2016, and that I precisely the reason why Srimati S. Weir has issued the certificate which I had submitted before the Commission. As to how and why Srimati had prepared another certificate stating otherwise is very strange and amounts to misrepresentation. The accusation against me by Srimati S. Weir is not only defamatory but also affected my candidature for the post I have applied.
Now this, you are S-Weir, isn't it?
Yes, my lord.
Now, S-Weir had approached the PIO, PSC by RTI petition.
Yes.
And submitted certificate bearing of so.
Yes.
So what does it mean?
What this means? This means this, my lord.
It means.
Yes.
Like, you yourself have approached PIO of MPSC.
Yes.
But then the RTI application which you showed us.
Yes.
It was signed by somebody else. That information was sought.
Yes.
By somebody else, not by you, isn't it?
I'll explain, my lord.
No, just
yes.
Just let us clarify. You explain once, could understand the.
Yes, my lord.
Problem first.
Yes, my lord.
So far is the.
Yes, I'm getting.
Narrative made in the FIR. If you go by the narration, it says S-Weir had approached the PIO.
Yes.
Of MPSC by RTI petition and submitted certificate. Now, how can it be this thing? You approach PIO with RTI petition.
Yes.
You are not to submit anything.
My lord, let us come back to little.
I submitted a certificate number so and so, where the year of my service. This is very confusing.
Yes.
That part has not been.
Yes, I'll explain to my lord very clearly, my lord. Let us recapitulate what was allowed by the PIO, Dashimti Kharkongor. Dashimti Kharkongor was allowed to peruse or examine.
Yes.
There she found that documents 2016.
Yes.
That was informed to me. That was informed to me by Dashimti Kharkongor.
That was known to you.
Sorry.
The person who applied for RTI application.
Yes.
She was known to you.
Yes, she was known to me because she is a assistant state organizer. She has written to me clarification page 5. Can you look at page 5, my lord? Oh, sorry, Annexure 5, page 25, my lord. Can you look at this one, my lord? After she was allowed to wait to go through this thing, to the documents of the private respondent, she wrote this one to me saying that request for clarification in connection with RTI inspection report received by the undersigned from Meghalaya Public Service Commission. Madam, with reference to the subject set away as per the RTI application filed by the undersigned against the Meghalaya so and so, the undersigned letter number has been allowed to give a chance to see, inspect and witness in person all the documents relating to the eligible candidates selected and published by the Meghalaya Service Commission. In view of the above, the undersigned would like to apprise you that as per the RTI inspection report, it was found that Srimati Alvarina Nongsij was appointed as assistant organizer since the year 2016 by the Meghalaya Bharat Scouts and Guides as non-salary staff duly signed sealed from your end. In this regard, the undersigned would like to seek clarification from you whether Srimati Alvina Nongsich has really been appointed as a state organizer as mentioned above. And also, it appears that the above matter falls entirely during your tenure as a state secretary of the Meghalaya Bharat Scouts and Guides prior to your retirement, anticipating your positive response. This is how I came to know.
So this Dasmiti Kharkungar
Yes.
was known.
Of course she was known. Yes, of course she was known because she was an employee.
And she was also known to probably the complainant.
Yes, because Dashimti.
That is where she.
That is why.
That certificate.
Yes, that is exactly. So therefore.
Otherwise, making personal contact.
Yes.
Normally, you do not see.
We don't see.
Until unless there is a reason to suspect.
Yes, exactly.
So definitely, she suspected that certificate.
Yes. So that is why she wrote to me this one. Now, what happened? MPSC has asked clarification from me also. Therefore, I submitted that because I retained a Xerox copy with me. A Xerox copy with me somewhere in my files. So I gave to the MPSC, see, this is the certificate actually I've submitted 2018. And I also asked RTI.
You retained a duplicate copy of certificate.
My lord, what happened was that, see, I am still, I'm patron.
If you say duplicate, that means everything has to be identical, except the part which has been manipulated.
Yes. So, yes.
Now, if you see these two certificates,
yes.
Apart from 2016-18, there is another difference.
My lord.
Whether that has come to your thing or not, but the court has noticed it.
My lord.
We will come to that anyway. Just
my lord. My lord.
If you say it is a copy,
yes.
Then it has to be a replica of the same. There has to be.
Yes. So now, my lord, that is the reason why I wanted to also know that what certificate, what's the experience certificate which I've issued to the respondent number 3 or the private respondent, she has submitted. I wanted to know the copy. Therefore, I filed in RTI. RTI. Now this is, she is.
Therefore, you filed RTI.
Yes.
Where is your RTI application?
RTI, my lord.
Your RTI.
My RTI, my lord. My RTA, my lord, I have not enclosed, unfortunately, here. But, and that RTI was not allowed, my lord. The copy was not furnished to me. I had to go to the appellate authority, my lord. Appellate authority, and the appellate authority had allowed.
Okay, next 3.
No, that is not the one.
Annexure 3 is not by him. It is by that other lady, Dasmiti Kharkungar.
My lord, I have inadvertently. Yes, but this is.
I don't know how much relevant that would be.
Yes, my lord. Here, my lord, just to clarify, my lord, from the public information officer, this is 2nd February 2022, from the public information officer addressed to Srimati Esware, post of state organizer, with reference to subject letter, your letter forwarded to the honorary chairman, you are hereby requested to appear on 4th February 20 at 12 noon commission room, along with the original copy of issued by you to Srimati as the enable commission to take necessary action. So, my lord, I was also.
This letter has not been enclosed here.
This has not been enclosed here. But, my lord.
Is it not vital?
It is very much vital, my lord. My lord, if my
Otherwise
lord.
The question will come.
Yes, my lord.
How is he like both these certificates?
Yes, my lord.
Become a part of MPSC record.
Yes, yes. No, part of the MPSC record, my lord, the first, the certificate that has been submitted by the private respondent 2016, it is a part of the MPSC record. Because she is the one, she has submitted.
2018 also you say you have submitted.
Yeah, 2018, my lord, by this order, by this 2nd February order, this order was asked to produce the original. Now, I cannot produce the original, I'm not no more a secretary, but I am a patron. I still am a patron because we are, once you retire also, we remain a patron. Somewhere, so my lord, fortunately or unfortunately, rightly or wrongly, my lord, some of the certificates in the duplicate, I mean to say the Xerox copy were in my custody. So I had that one. So the original certificate 2018, I've submitted to MPSC. MPSC, I've submitted that one, my lord.
Because retain it with you personal, in a personal capacity.
My lord, not as a personal capacity, my lord. I'm still a patron in chief, my lord. So, my lord, if my lord allows me 2 days time, I will file this in by way of an additional affidavit and also my RTI applications, my lord. Inadvertently, my lord, those has been missed out, my lord.
Thing has become quite interesting.
My lord.
It seems if we go by the FIR,
My lord.
it seems you initially issued one certificate.
Yes.
And subsequently you changed it.
That is her allegation.
With some motive.
What could be
the filing of the FIR?
My lord, what could be the motive, my lord?
Just a minute.
Yes.
The court is not giving his finding.
My lord.
Just
yes.
Disclosing what transpires, basically.
My lord.
Now, if FIR divulges that kind of story, then there is a prima facie case against you.
My lord.
Interference would be quite tough. It is not a case. You see, like this, the initial impression was that, like, you are the issuing authority.
Yes.
And how you yourself forge your own certificate.
Exactly. That is exactly the case only, my lord.
If it is done.
Yes.
With some motive.
My lord.
As has been reflected in this FIR.
Yes, ma'am.
Then there is a case against you. Prima facie case against you.
My lord. Here, my lord, what I am saying. The signature board belongs to me. Now, let's put another scenario, my lord. Now, the signature belongs to me. I am saying, as an issuing authority, one certificate I have issued. That certificate is not qualifying the candidate eligible to appear for the post. Now the candidate in my signature itself takes manufacture tamper to the year, I don't know, because I was on the bona fide and I don't have any intention to cause harm to her.
What is your stand before this court? Which one is a genuine certificate? This is the first one.
2018 is my genuine.
The second one. The other one you want to say that has been forged.
That has been forged.
Have you filed any FIR?
She should be very happy. I am a 72-year-old lady. I don't want.
Have you filed any FIR?
No, I have not filed an FIR, my lord.
Why?
My lord, that's what I'm saying. I don't want any person to fall into trouble because I'm a 72-year-old lady, and all this
criminal charge against you. So those kind of assertion may not help you much.
My lord, exactly, my lord. But try to understand, try to grasp my intention, my lord. I am the secretary, my lord. I treat every children and every employees as my own daughters. Why would I have an intention to bring charges against them? If I want, I can do today also.
See, this is what you say.
Yes.
But then more requires something else.
My lord, exactly, my lord.
You see, what we say, what we know, you see, may not always work.
My lord.
In a court proceeding, whatever the document says.
Yes.
See, a man may lie, a document will never lie. There's okay.
That is true, my lord.
That is what the proposition which remains.
Yes.
In the courtroom, you see, that saying is given priority. Okay, what is there? And you see, now it appears that there are two signatures.
My lord.
Sorry, two certificates. In both certificates, your signatures appear.
My lord.
Now, what is a genuine signature? So what is not a genuine signature?
Yes.
That also required to be determined.
Yes. Yes.
If you had to be given a clean sheet, then that is vital thing.
Yes, my lord.
So these things, how this court will do?
My lord. My lord, here, my lord, I quite get it. What my lord is saying now. My lord, here, by submitting 2018 certificate and by submitting 2016 certificate, my lord, who gets the benefit?
You may not get directly, but then a third party may be a recipient who is known to you, who might have used you.
My lord, the third party.
Third party who initiated all those things.
My lord.
It seemed that she knew this everything. And that is why she has written to you.
My lord.
Seeking a clarification with regard to that certificate.
My lord.
Otherwise,
somebody, my lord, somebody who stands for the truth and says that something is going wrong. We can't be faulted on somebody who is trying to bring something which is going wrong.
This court is not saying you are guilty. Not
my lord.
You are guilty.
My lord.
This court is simply saying that there are enough materials.
My lord.
Which make it clear that yes, there is a case for proceeding against you.
My lord, if there is a case for proceeding against me, my lord, then what about that angle, my lord, where the suspicion arises for submitting of the false certificate and trying to get the benefit of this false certificate?
You know, at the stage of 482.
My lord.
Whatever disclosure is
yes.
made.
Yes.
In the documents of the investigating authority.
My lord.
That has to be given priority.
Exactly, my lord. Now by reading this one, my lord.
Your version of story.
Yes.
It may be very appealing. But
my lord.
It cannot become
the best
factor for consideration of this case.
My lord. Now, my lord, I'm grateful my lord appreciates the factual aspects of the matter. Now, my lord has seen the FIR, my lord, which penal provisions attracts. She herself says it's very defamatory to me. And now I have been alleged of, now when she says that this is the documents, she has manufactured another documents. Manufactured another documents who? Me. Under my signature.
That is what.
So can I be alleged of...
If it is guided by some motive.
My lord, how do we...
No one will do it.
My lord, how do we...
But then if it is guided by some motive.
My lord...
You find that somebody's candidature should be supported.
My lord, if I had a motive for her to not prosper in her life.
Determine it.
My lord, why?
Let the trial determine it.
My lord.
You see, what section and what not section may not be much vital at this stage. You know, 216 is there.
My lord.
Okay, court can alter charges. Charges can be altered anytime.
Yes, my lord.
It is not that whatever section has been put by the investigating authority, court is bound by that.
Yes, my lord.
What requires at this stage is whether the FIR discloses commission of crime against you. That is the main thing.
My lord, I ask a question to myself, my lord. Which penal section attracts the FIR here?
That they will explain.
Exactly, my lord. If not, then why would I be
court will
put to...
for their...
Yes. Why would I be put? I'm a 72-year-old. Yes. Now, my lord, if I have a motive not to give... Why would I give such a beautiful certificate?
Is it your case,
my lord,
that assuming,
my lord,
the story or the narration of the FIR,
my lord,
is, or rather the whatever the allegation is accepted to be correct as against you, even then also that will not constitute any criminal case? Is it your criminal charge against you? Is it your contention?
My lord,
if you say that,
yes,
say that,
yes,
that the disclosure made in the FIR would constitute.
My lord, if the FIR discloses any penal charges against me, my lord, in the first place, I will not be invoking 482, my lord, here in the first place.
We can curtail it. We can just simply, you see, basically say that your submission is confined to the fact
Yes.
that you say that if this entire narration made in the FIR is accepted as correct, that will not constitute
Even
any criminal case against you.
My lord.
So if that be the thing, if that is accepted, definitely you have a case. Then we'll just tell them how. Tell us how.
Yes, my lord. Yes. So that's why I was building up my case, my lord. Finally, to say that, my lord. Now, my lord, have read. They're saying that what she said very clearly. She said that this has been submitted. This has been another documents. Another documents under whom? Under my authority only. She did not say that forged document. She has manufactured another document.
This FIR will say everything.
My lord. No, exactly, my lord. But at least some substance.
It is only information based on which one investigation starts.
Based on the information, the preliminary investigations, whether the allegations are correct or not.
At this stage, we only see whether FIR discloses commission of a certain offence.
Exactly, my lord.
That is what we will just see.
Yes, my lord. So now, my lord, when she says that I have manufactured another documents, my lord, what was her basis of saying? Because I am saying that this is the copy which I have given to her, and that is not the one that's been submitted to you, to the MPSC. This is not the one. This is not what I have certified to her. This is the one I have certified to her. When I am showing the correct picture, can I be held liable for a penal consequence? This is what I'm saying. Where is the ingredients?
Whether you are saying it correctly or not, whether there is a true disclosure by you or not, that is what the trial will decide.
My lord.
Who knows, there may be a change of heart by you. Initially you issue one certificate and subsequently you change.
My lord.
Okay, so all these things would be seen.
My lord, but then, yes. Yeah, that is there, my lord, but can you look at the more?
One thing is that
yes,
there appears to be two certificates issued by you.
Yes.
And the FIR somehow discloses that there is a reason for doing that.
Yes. And then, my lord, FIR...
It is not that
yes,
a simple case that what you will gain by doing this.
Yes. FIR, two certificates comes to the MPSC. Then only the FIR comes. Then only the FIR comes.
Definitely.
My lord.
The authority is satisfied by that only.
Yes.
Or the person, the maker of the FIR.
Yes. So, and also, my lord, we cannot lose of the facts that, my lord, MPSC was going to take an action against the private respondent. Then she jumps and files an FIR against me, my lord. And coupled with this, my lord, if I wanted to destroy her career, just let's say for assuming, why would in the first place I give such a beautiful wording?
That is why the court said there may be a change of heart.
My lord, when somebody who has no interest at all is...
See, why to dwell much on those factual aspects?
My lord.
You see, whatever we see, you say one thing,
yes,
they counter it by saying another thing. This court will not come to, you see, will not be able to come to who is saying truth, who is saying lie. It is not that. Only thing is that whether there is a disclosure
yes,
in FIR and whether disclosure basically points
yes,
towards commission of a criminal offence or not, that is what is to be seen. If
exactly, my lord.
That is what.
Exactly, my lord. So, therefore, my lord, here, my lord, yes, today I admit, it is me who should have been filed against FIR against her. By my good heart and good gesture, did not curtained me, my lord, from destroying somebody's career, my lord.
This is, for you, it's a good heart and gesture. For
my
them,
lord,
that may not be.
My lord.
That may be something different.
My lord. So, my lord, all I understand, my lord, is here, my lord, here is a case. Somebody tried to file a false documents to secure a job, and when that has come to the picture, in order to save one's skin, file an FIR against the author of the certificate. That's why I say that this
Even
was an
after she
abuse.
filed an FIR against you.
Yes.
You did not file counter FIR.
No, I did not file a counter FIR, my lord. No, my lord, that.
You were so nice.
My lord.
That you were ready to go behind the bar, but then you would not take others to the wrongdoers. You will not send the wrongdoers there. Anyway, just tell us when is the date when you filed this thing, when you filed your RTA application. Let us compare it with these things when the others have filed. But then you should have put it.
My lord,
before the thing.
kindly give me 2 days. I'll
So
file by way of an
let us
additional affidavit.
see. Senior counsel has been waiting here to say something. We can make it from his smile that he has many things to say.
My lord.
Your Lordship, my learned friend has left out the most important annexure to his application. If Your Lordship will come to page 26. This is the reply of the petitioner to the letter submitted by Dashimti.
Yes.
My Lord has indirectly said, what exactly is this case about? The petitioner here is espousing the cause of Dashimti. The records would go to show that after she issued a certificate to me, saying that 2016, another certificate was made or was forged or whatever by the petitioner. And here, my lord, at page 26, your lordship will see what is the reply. I am deeply shocked and saddened to hear the RTI inspection report from you and also express my willingness to clarify the following facts and figures as per my record during my period as the State Secretary, Meghalaya Bharat Scouts and Guides, State Headquarters, Shillong. I would like to clarify to you that as per the original experience certificate issued and duly signed from my end, it does not match with the RTI inspection report mentioned by you in your letter, which on the other hand confuses me a lot. I remember carefully that the original experience certificate issued to Srimati so-and-so, duly signed by me as per my record, she was given a certificate as Honorary Assistant State Organizer in the year 2018 and not 2016. And she's underlined this. As mentioned by you in your RTI inspection report, the certificate was issued only on her request with good intention to help her in promoting, scouting and guiding, but unaware and deeply shocked that Srimati Alvarina Nongsage has misused the experience certificate by tampering and forging all the original information duly signed from my end without any consultation if the matter was true as per your RTI inspection report. Now, my lord, surprisingly, a record copy of the experience certificate issued to Srimati Alvarina Nongsage duly signed from my end is enclosed herewith for reference. That is when the 2018 certificate surfaced. Who is she, my lord, to espouse the case of the other candidate? How did she retain a certificate of 2018 after she has retired? That is why, my lord, if my lord will go through the charge sheet filed by the police, I just had a glance. She has denied signing the certificate of 2016. But the forensic report says otherwise. That she has signed in both these certificates. And another interesting fact is that,
Then definitely
that this lady has also filed a writ before this court. Dashimti Kharmor. That aspect is different. But here, my lord, will have to see what this case is about, is whether the petitioner had signed the certificate of 2016 or not. Prima facie, my lord, as per FSL, she has.
That is what the basis of this.
Yes.
My
Your
lord,
lordship is very well aware of Bhajanlal and all these cases.
My lord,
482, when it is to be
Bhajanlal
exercised.
still holds the field.
Still holds the field.
my lord, this letter, my lord, kindly look this letter which my senior has referred to, my lord. Crystal clear. Where is she is only replying to the clarification sought.
That is all right. We do not go by the letter. But then what about the thing?
Yes, my lord.
Forensic then.
My lord, I think
Forensic, my lord. One thing I must.
Anyway,
I must say.
you just sit down. Let Mr.
But
Guru
just
say
one
something.
second, my lord.
You can give a reply at time.
Yes, my lord.
It will be easier for you.
Yes, my lord. But forensic and charge sheet, what they're saying, my lord. We are yet to be summoned.
Yes.
Charge sheet isn't in the custody of the learned PP. Yes. How did the private respondent get an opportunity to glance at a charge sheet? That has to be noted, my lord.
Can it be ground for interference?
No, my lord, what I'm saying is, my lord, that is why I'm saying that there was so much of connivance.
They are on the same side now. And
there's so much of connivance is what I'm saying.
Just now to become successful in this case. See, how much? See, I don't think this kind of things will really help you in this case.
My lord. No, but I'm just saying, my lord.
Will be just confined to the issue whether FIR discloses a cognizable offence or not.
Yes.
And if that is the thing, then we will not interfere.
My lord. My lord.
Yes.
My lord, I think...
you are the main person actually.
My lord, yes.
It is the senior counsel's smile which basically made the court.
May I have the privilege of, my lord, assisting the Honorable Court to give a final quietus to the matter, my lord. Firstly, my lord, this present petition is not maintainable, my lord.
Well.
Kindly come to the cause title, my lord, and the page number 1, my lord. Page number, may I read, my lord?
Yes.
In the matter of an application under section 482 of the Criminal Procedure Code 1973 for quashing of the Sadar PS case number 01034/2022 under section 468 IPC. My lord, I'll take a pause here. On the last occasion, my learned friend had been harping on this section being quoted in there. It is most inappropriate. But my lord, serious confusion was being caused because of this. Actually, my lord, the charge sheet has been filed under section 177, my lord.
We are not at all concerned with this.
Yes, may I complete, my lord? So, charge sheet, in the charge sheet, nowhere this section is, my lord.
So,
177 read with section 500. Secondly, my lord, coming into the two contradicting, my lord, certificates. Kindly peruse the, my lord, FSL report. The author of both the certificates
are the same.
Has been same and pointed to the present petitioner here, my lord. So, my lord, we have got ample of evidence to carry on with the trial, my lord. So, at this juncture, my lord, 42, my lord, will not.
If that be the case,
if you issue something and if you deny that also will be crime.
If that be the case, my lord, if that be the case, two certificate, FSL says that it is my own signature, my lord. Can I be tried for issuing two certificates under my own signature?
Yes.
When it is done with someone.
On 177, it is.
Wait, how you will justify?
No, my lord, I'm just...
How you justify issuance of two certificates in one name, giving two different this thing? That is there where
in the FIS, my lord, in the FSL, that report has come whether 2018 and 2016, these four digits has been tempered or not, or one digit has been tempered or FSL has come.
FSL says that in both the certificate your signature appears.
Yes.
That is good enough to hold prima facie case against you. Come to your certificate.
My lord.
Let us just go by the assumption that both the certificates are signed by you.
My lord.
We are moving on by that assumption.
Yes.
Your first certificate, along with signature, you have put the date 9/3/2021.
Yes.
Isn't it?
My lord.
And yes. See the second one. The date is not there with your signature. So that shows these are not prepared at a time. Though you may say that, you see, you have retained a copy and all. So this all you have to answer. Come your second certificate at page 29.
Yes, my lord.
There is no date.
No date, yes, my lord. So, my lord.
You will explain all those.
My lord, this is what I have clearly stated, my lord, that this is not a certificate issued by me.
That is what this court will do, this thing. So one forensic report is against you. When did this RTI of this other person, Dasmiti Kharkangar, was on? She wrote a letter.
Well, the RTI, my lord, the RTI of this lady.
She wrote a letter to you on 12/1.
This was on the application, RT application was 14
You
November.
have given her a reply on 14/1.
Yes, my lord.
Then when was your RTA application filed?
My RTI application,
when
all this was
Dasputi's
after.
RTA?
My lord, let me bring by way of an affidavit, my lord. This RTI file, we have not brought here the RTI file of the SWR, my lord. Just 2 days, my lord.
Why would she be so interested even to file an RTI?
You see, like, and think over. If there appears to be
something is wrong.
My lord,
what is that forensic thing, Mr.
My lord,
Guru?
at the last page, my lord. The finding is in the last page, my lord. Last paragraph. We have made a very elaborate investigation, recorded our statement.
Last
both the-
page. No, last page is not.
My lord, I don't have a copy, my lord. Second
Please,
last, I think.
you make a copy.
My lord.
That is what the court had asked you at the beginning.
My lord.
Initially. Finally, please.
Thank you.
Make copy.
I'll provide.
Once charge sheet comes,
my lord.
is it not required that you should go through the charge sheet before you make? Is it say like how you will argue this case? This FIR is against this. Your challenge is against the FIR, isn't it?
My lord. My lord.
Now, meanwhile, charge sheet has been filed.
My lord.
It's not required for you to amend the thing. Is it?
My lord, at least, my lord.
They can give a copy. No, the prosecution can give them a copy, and if they have anything to say, they can respond.
I came before my lord, quashing the FIR, my lord, the FIR, my lord.
The last portion, my last part.
Yes.
That was a separate scenario, my lord. At that point of time, I was coming that this is the abuse of process. There's no ingredients of it. Yet they have registered investigations going on, my lord. Today, if they say that there is so much of incriminating evidences against me, my lord, then, my lord, I will take instructions appropriately, my lord, and challenge the charge sheet, my lord. But give me a 2 days time. I'll just take instructions, my lord.
Definitely, you'll get this matter. We'll have in next week, not
my lord.
This
My-
$500 is 500 IPC is what? Defamation.
Defamation.
If it is non-cognizable.
Yes. 177, what they're saying is giving false information. Giving false
That would be
information.
amount to give false information. Moment you deny that you have issued that subsequent certificate,
My lord.
that would amount to false.
My lord,
if it is proved against you.
My lord, if it is true that I have given and I'm denying, yes, 177. But
177
here, my stand is, my lord, I have not issued 2016. And when this lady was not even working there, how would I issue?
That is, investigation will find that. We have found.
That investigation is completed now, you has no job to do.
Matters of facts.
My lord, my lord.
And Mr. Gurung, you just take it back,
My
make
lord.
Xerox copy and then.
My lord.
Just do. And you will supply him also a copy of charge sheet.
My lord.
There is no bar. It is
No
not
bar,
a-
no bar.
Since it is charged.
Applying court may take some time, my lord. If
I'll provide, my lord.
Just say hard. Make all the counsels known. Mr. Alvaru, Learned GA has produced a copy of the charge sheet submitted in connection with has placed a copy of the charge sheet before this court submitted in connection with Sagar case number 103 within bracket 04 2022. Mr. Evan, learned counsel for the petitioner, submits that a copy of the charge sheet may be supplied to him so that the same can be gone through by the petitioner. before this matter is taken up for final disposal.
My lord, whether this cause title will be required to be changed because he has referred wrong
Court section. It is not needed.
Madam.
See, once case number is generated,
Deeply obliged.
then you just say, so. Mr. Guru would supply a copy of the charge sheet to the counsel appearing for the petitioner within 2 days.
My lord.
2 days.
My lord.
This is matter after a week. 2 weeks.
2 weeks, my lord.
Yes,
Oh, my lord.
Deeply obliged.
Obliged.
Interesting.